indicate that the defense rests, then I'm going to, of course, explain to them you've now heard all of the evidence that is going to be presented in the case, and then I'll excuse them again, and then we can talk about instructions. Does that sound like a plan?
Unless you want to talk about anything?
I mean, we can talk about those now and then avoid having to send them back again.
I think that makes more sense. I think we're pretty, I have no objection to them. They seem okay to me. So.
That's fair enough. Hang on a second. Would you get Nick out here, because my law clerk is the one who actually has been dealing with this. My impression is, Mr. Becker, that you asked that Ms. Boz also be listed as an expert. Is that correct?
That's correct. I think we did end up, she stipulated to it, and we put it on that way.
That's fine. And do you have any issue with that, Mr. Kirkhoff, of also? And I believe that what you currently have now does include Ms. Boz. I think the revised, this is on page 4, an expert witness. Are there any other issues that either counsel wants to raise regarding these? Again, I think you got a slightly revised version this morning. I want to make sure you both have the opportunity to review them again. Is there anything else that you want to raise? I will say this. There was a request for voluntary manslaughter. The Michigan Supreme Court decided a case just last term, which suggests that if there is any evidence that would support voluntary manslaughter instruction, that the court should give it. I believe you requested it, Mr. Kirkhoff, and after reviewing again the transcript of the actual interview of the defendant, I think there's enough there to give the instruction. Do you agree with that, Mr. Becker? I mean, I'm sure
the court's decision, but I agree with that. I think given that decision, we have to.
Yeah, that's fair enough. So that means that they're really going to be instructed now on 3 particular crimes, specific crimes. One is first-degree murder, one is second-degree murder, and then they'll also be instructed of, I guess, what we would call a lesser included offense, which is a voluntary manslaughter. Any other objections or issues that either counsel wants to raise? Because if we've covered the instructions, we'll bring them out. I'll have Mr. Kirkhoff indicate that he rests, and we can move directly into the instructions. Does that sound like a plan? Any objections to any of that?
Yeah, we're going to do instructions before closing?
No. Thank you for reminding me. I just want to be sure we're all on the same page.
We are. Well,
then,
I have
then
no objections to the
you have no objections then. So then we'll go into closing, and obviously I'll also explain incidentally that the people do get a rebuttal, just so that they also understand. And I explain why that is, because the people bear the burden of proof. Sound like a plan?
Well, without me putting anybody on, I don't believe he has a right of rebuttal.
You don't think he has a right of rebuttal in a closing argument?
Oh, closing argument.
I mean, no. He doesn't have a right to a rebuttal case because
That's
you didn't
correct.
put on any case. Right now, we're just talking about closings, and I think he still gets the last word on
I
closings.
think that is correct.
Okay, that's fair enough. Should we bring him back already? Let's bring him back. And it'll take probably just a moment for them to line up.
I think Kathy has.
Oh, Kathy may already have them lined up, so let's go ahead and everyone rise, please. And we can all be seated. Thank you very much. Ladies and gentlemen, before I excuse you, the people had arrested its case. I'm now going to call on Mr. Kirkhoff. Mr. Kirkhoff, has the defense made a decision as to how you would like to proceed today?
Yes, Your Honor, we will not be presenting any witnesses.
So the defense rests as well?
Defense rests.
All right. Ladies and gentlemen, that means that you have heard the evidence that you are going to hear in this trial. Let me remind you of what remains. What remains are the closing arguments of counsel and then ultimately the final instructions that I'll be giving to you. I think I explained a couple of days ago that counsel and the court try to reach agreement on instructions. We've been successful in being able to do that. So that means that we'll go from closing arguments directly into the final instructions, and then after you get the final instructions, that's when we take it from 14 to 12. Not my favorite thing to do after people have sat through it. That is when we bring the juror number from 14 to 12, and then ultimately you can begin deliberations. I hope that all makes sense. I do want to also point one more thing out. In closing arguments, the prosecutor, Mr. Becker, goes first. Then Mr. Kirkhoff, on behalf of the defense, goes next. The prosecution does get a rebuttal argument if it chooses to use it. The reason that the prosecutor, if you will, gets the last word is because the burden of proof rests on the people. And that is the reason why they do have the right to rebut if they choose to do so. So I hope that all makes sense. Mr. Becker, are you ready for your closing?
I'm ready.
I'll turn it over to you.
Thank you. I will need the screen with a PowerPoint. You can probably leave the lights on and so on. Okay. Every time you think about this case, it's shorter and shorter how to describe it. This is an execution. I mean, that's what it was on May 31st. He executed Leah. And when you think about it, an execution, what is it? It's an intentional act. It's something that's deliberate. When you think about, when you use the term execution, it's not, well, mistakenly, you don't accidentally execute somebody. I suppose you could do the wrong person, maybe. But execution is something that's intentional, it's deliberate. It's first-degree murder. And that's what you have to decide. It's maybe just a one-word version of first-degree murder. So I'm not going to go over a whole lot, go over the whole case for you, but I think when you get down to it, when you look at the elements that the judge has already given you, the elements that you will hear once again, because we're going to go over it. Well, what is it? A death caused by the defendant in terms of multiple gunshot wounds. That's the first thing. That's the first element. Well, we have that. We have a death caused by the defendant because he killed Leah and executed her. So what is the intent? Well, just think about that. The intent to kill, and I think the first thing, just a simple intent, is this. You use this against another human being. That's an intent to kill, simply. There's no other explanation about it. You're not going to point this and fire 7 times. Well, I was just trying to murder. No, that's an intent itself. That is an intent to kill when you use a weapon in that fashion. And what else do we have up there? Look at those bullets. Look at those bullets. Those are not small bullets. That's an intent when you're using bullets that size against another individual. Okay, demonstrating intent. And for some reason, I don't want to go over it too much. If there's some confusion on, wow, did he really do it? I mean, you remember the testimony. These are the Wolf 223 casings that are found on the side, with the Wolf 223 casings that are found in that weapon that are found in the defendant's apartment. This isn't a question of who done it. Okay, this is a question of what is it. So I just want to put that to the side. If for some reason you don't trust the confession, there's plenty of evidence that shows he did it that day. We have his neighbor saying he sees him walking in with a gun just after seeing the gunshot shots. So that's all an intent to kill. That's your first, the second element, if you will. It is an intent. Well, then it gets maybe a little bit more. Okay, what does that mean? The judge is going to talk to you. One of the elements, premeditation. Premeditation. What does that mean? Thought out beforehand. Okay, that's simply thought beforehand. We talked a little bit about in jury selection, right? In jury selection, when we talk about, you can premeditate to go out to dinner, and you can plan a month in advance, and you can make the reservations at Leo's, you can plan out for drinks, and maybe you plan your Lyft driver so you don't have to drive home drunk or something like that. Premeditation doesn't mean that. It doesn't mean a full-blown plan. Premeditation can happen when you go home at night. Decide we're going to go to Red Lobster because we don't have any food in the house, and we just want to get done with things. Okay, that's premeditation. It doesn't mean that you have a whole full plan. So what do we have for premeditation here? Well, maybe one photo. I mean, this is a photo of premeditation, and then once again, there's not a separation, if you will. Okay, you can't, use one thing for intent, one thing. This is all interaction. Once again, premeditation is getting a weapon like this. Premeditation is leaving Leah outside her car, walking back into your apartment, finding the gun. Because you remember the evidence, what did he say? He had to go find the gun that was it was up high. You remember telling me? He had to find the gun, get the gun, and what? Wrap it in that blanket. The blanket that's in the evidence. He had to wrap it in the blanket. That is premeditation. He's thinking about it beforehand. That's a plan. To go then walk out and fire those shots. That's all that, those are steps that happened before he even fired the shot. So that is premeditation. It doesn't, like I said, 7 minutes, at least 7 minutes. Because that's when you start looking at the security photos that was taken. So 7 minutes of planning, if you will, is plenty of time in terms of thought out beforehand. So you have premeditation here. So what's the next thing? Premeditation and deliberation, because you're going to hear about this. So deliberation, that's what it kind of maybe boils down to me. The key thing is deliberate, real and substantial reflection for long enough to give a reasonable person to think twice. Okay? Does he have enough time to think twice about what he's about to do? I submit to you, I think it goes beyond 7 minutes. I've talked a lot about 7 minutes, but let's look at the evidence here. Okay, when you look at it, I think I got the laser pointer here. Pay attention to the times. These are all exhibits, exhibit 17. You can barely see it. 2:51. So 2:51, he's taking his daughter out to Leah, right? What does that tell you? She's on the phone already, right? That's the triggering event here, that he's mad. She's on the phone at 2:51. He knows she's on the phone. You know, whatever, you know, thinks it's a friend, thinks it's a boyfriend, whatever, he thinks he's cheating on her. Well, how long does this happen afterwards? He goes in and out. It's 2:54, he comes back in, he goes out at 2:57 with the bag. We don't have him, we missed, him coming back in, but we know he's leaving again with the oxygen tank at 3:01. Okay, that's time. This is time, once again. He knows from the beginning she's on the phone, and you hear the testimony of Jose, the very first witness, who's actually on the phone when this all goes down, saying, yeah, I'm on the phone, there's nowhere, I don't hear you screaming, yelling, anything crazy. But he knows that this is going on, she's on the phone, and then once they can say that there's a hang-up at that point in time. So in terms of deliberate, he's got all this time on top of when he comes back in at 3:07. At 3:07 to get the gun, to get the weapon, to cover it up, to go back outside. That is enough time for a reasonable person to consider what the heck they're doing. That's what we're talking about here. He's got plenty of time. This is not something that all of a sudden pops out. So then what else? Because your part of that instruction is what? Killing cannot be of a sudden impulse. Is this a sudden impulse? Watch this video. Is that a sudden impulse? Is that somebody enraged? I'll play it one more time. He's like walking to the park. Is this something it's an impulse. An impulse is, man, you're not thinking. He's mad, he's angry, she's talking to another man, he's jealous. Is that somebody jealous? Get the gun, just kind of waltzing out there, covering it up. Okay? And so, once again, this impulse, he's so enraged that he's got enough sense to then cover it up when he comes back in, trying to hide it. I mean, this is all, once again, he's trying to hide it. He's covering up that gun. Once again, going to the deliberative part, going to the intentional part, he's hiding the gun because he doesn't want to get caught. He doesn't want to scare her off. That's all deliberation. That's intent. He doesn't want to get picked up. He knows there's cameras in there. He's thinking enough. There's enough in his head that he's trying to cover everything up. That's not a rage. That's not an impulse. An impulse is you're not thinking straight because you just react. This isn't just simply a reaction. This is a plan. This is intent. This is him wanting to kill her. Now, he may be mad. He may be not happy with it. But I think there's one other thing. I'm going to show us once again, going back to what just said. There's going to be pictures of her, Leah, right now. This is controlled. This is something that's controlled. Because why? Okay, he was just outside, maybe 4 feet away, just by the car. But somebody who's enraged, who's with jealousy, there's going to be something that, oh my gosh, he acts on impulse. But he doesn't manage to do anything, hit anything in the car. He's not firing wildly, right? He's got what? 5 shots across another one of the face. All headshots. I know he's close, but that's pretty darn good. If you're really enraged and you can't think straight, and here's jealousy driving you to that. He hits a pretty darn good target at a close range because he's under control. He's under control, and you see that when he walks out, he's under control. He's waltzing out like he's going for a Sunday stroll, but he's going to go kill his girlfriend. And it doesn't affect him at all. And that's what we're talking about. Premeditation, intent, deliberation, it's all there. this is a first-degree murder. You're gonna hear something. You've heard about first-degree murder. You're gonna hear second-degree murder. You're gonna hear a third thing. There is a lesser offense you can consider. Voluntary manslaughter. This is not voluntary manslaughter, because that's what the argument is. It's, once again, this rage. The elements for voluntary manslaughter is the defendant acted out of passion or anger brought about by what? Adequate cause. What's the adequate cause here? She's on the phone? Being on the phone with another person? That's adequate cause to go out and go get this weapon, an AR-15, and shoot her 7 times because she's on the phone with somebody else? And at this point in time, if you remember this friends, it's not like she's talking to him. You heard, going back to Jose, they're not saying, aha, I got another boyfriend, I hate you, you stink, you're a worthless piece. No, it's a friend. They're on the phone. So he loses it because she's on the phone. That's not another thing you can do, because what's the other 2 things? There's all this talking about reasonable. A reasonable person might have acted. A reasonable person. Is anything about this that make a reasonable person act in this way? A reasonable person goes and gets a gun because somebody's on the phone with somebody he doesn't like? That's not reasonable. It's not the jealous boyfriend standard. It's not the jealous ex-boyfriend standard. It's not, well, this person's a hothead. It's a reasonable person. Reasonable person, people don't act this way. There's nothing reasonable about this reaction. So if it's not reasonable, what is it? It's first-degree murder. And that's what you have here. It doesn't meet the test for voluntary manslaughter. And once again, acted before a reasonable amount of time has passed. We've gone over this. I don't want to try and beat a dead horse, but going over it, but a reasonable amount of time is 7 minutes. 7 minutes to think about what the heck you're going to do and say, what the heck? I think it's more than that. She's been on the phone since 10 to 3. And why is it taking almost a half an hour for him to get the stuff out to his girlfriend so she can leave with the baby? He's playing games here. He's playing games. He's drawn it out, not her. So nothing about this is reasonable. And that brings me to the final thing, what this is all about. You have the reasonable doubt standard. You have to prove it beyond a reasonable doubt. That doesn't mean 100%. It's maybe, you use your common sense. I emphasize common sense here because when you come in those doors, it's not like you leave your common sense that you have when you're on the streets. Maybe put it another way, common sense, if it doesn't smell test out there, it should pass the smell test in here. So think about it, if you're talking with your neighbor, and your neighbor says, yeah, I had a bad day today. My wife was talking to another guy, so I shot her 7 times. You're like, oh, that makes sense. Reasonable? Nobody'd say that's reasonable. He'd be like, what? That's just crazy. Why would you do that? That's nuts. That's not reasonable. So it's not reasonable here because you got a judge and all these instructions. It's not reasonable. And reasonable doubt is just that. It doesn't make sense to say somebody can blow somebody away because they're on a phone call. And that's exactly what happened here. This was an execution. An execution is just another way of saying first-degree murder. There's only really 2 reasonable verdicts. Guilty of first-degree murder because he intentionally killed her. 7 shots. He had plenty of time to think about it. He deliberated when he did it. And he used the gun with the commission of a felony. That's a felony firearm. The only reasonable verdict here is you find him guilty as charged. But I ask that you do that. Thank you.
Thank you, Mr. Becker. Mr. Kirkhoff, I'll turn it over to you.
I get one shot at you, and I just ask for your attention for a couple minutes. Mr. Becker will be able to get up here again and talk to you and get the last word. So I'm going to ask that you go with me for a few minutes and actually really listen. This case went a lot quicker than I thought, but I will try to make it a little bit easier for you to write out of the box. Did Mr. Bernal-Sosa kill his girlfriend? The answer is yes. I'm not going to sit here and insult anybody's intelligence by saying, well, it didn't really happen that way. He told the police as soon as he got arrested, yep, I did it. Took the police 5 minutes of interrogation to break him down. Wasn't much. But he admitted it from the very beginning. And yes, he committed a crime with a felony, so the charge of committing a crime, a felony with a firearm, is also guilty, and he admitted. Don't even have to worry about that. So let's look and see what really happened and what the proper charge is. And we feel the proper charge is manslaughter. Mr. Bernal-Sosa told the police, and this is really corroborated by the man who was talking to Leah at the time of the shooting. This was all because of jealousy. That was his girlfriend. She'd been cheating on him. He even thought that this person that she was talking to was the one that she was cheating on, although it turns out it wasn't. I don't know if that would make that much difference, because Mr. Bernal-Sosa was jealous, whether it be one person or two, and he calls her to pick up the child. She does. If this was premeditated, lying in wait, he would have gone out there and shot her the first time he came down. So therefore, that is really out from the very beginning. What does he do? He goes down there, he's unhappy. She's talking on the phone. Jose Gavina even admitted, yeah, she's talking to somebody, he hangs up on her. Not Leah hanging up on her. But while she went to buckle the child in the back seat, he hangs up on her. And obviously, Mr. Bernal-Sosa is not happy. Goes back in, walks in, and you see it takes 4 or 5 minutes to walk from the car up to the apartment every time. And that's what he does. He goes and gets the backpack first, I believe, and then he goes and gets the oxygen tank. And every time he comes down, she's still on the phone with this guy, and he's telling her to hang up, and he's getting madder and madder. He's jealous. There's no choice about it. Finally, on the 4th time, he decides, and I'm sure he'll regret it for the rest of his life, that he's going to go out and get a gun and shoot her. And that's exactly what he did. It wasn't the first time. He wasn't lying in wait, premeditated to kill her. It was something that built up as this incident happened, where he kept going down. She kept saying, I'm not going to hang up. I'm talking to him. As he told the police, she was laughing at him. It was something that when he went back in on the 4th time, it took him a minute or two longer than it took him to go up and get the oxygen tank or to get the backpack. That is not enough time for someone who is that ticked off about the situation to recover completely. This was not premeditated. And the court will tell you it has to be premeditated, thought out beforehand for it to be murder one. This was not thought out beforehand. This is something that built as he's going down and having contact with her, with the daughter being exchanged. In order to be first-degree murder, the court will instruct you there has to be real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. And that's up for you to decide whether it was long enough. It was only a minute or two longer than what it took him to do the other things, namely get the backpack and the tank. That is not enough time for reflection. In fact, he got madder and madder as it went along. And that is shown by what happened. Did he actually execute her? Did he go down there and shoot her once? No, he did not. He was 4 feet away, the width of the car. I think that's pretty much established. And what does he do? Does he shoot her once? No. He is so ticked off and in an emotional state. Shoots her 7 times. It doesn't take 7 times to kill someone. That shows his real state of mind. The judge will further instruct you that voluntary manslaughter is a killing, which we had here by Mr. Bernal-Sosa, which we admit. When the defendant acted, his thinking must have been disturbed by emotional excitement to the point a reasonable person might have acted on impulse without thinking twice from passion instead of judgment. That's exactly what he did. This anger kept building up all the time he was dealing with her, and the last time he lost. There's no two ways around it. The emotional excitement must have been the result of something that would have caused a reasonable person to act rationally or on impulse. He knew that she was cheating on her, apparently not with this person, but with somebody else. So it is something that has been building for a long time. And the killing must have resulted from this emotional excitement. Well, that's exactly what happened, because every time he came down, he was madder and madder about it. She wouldn't hang up. He hung up on this guy once, and it just kept getting worse and worse and building. So, the bottom line is, we're going to ask you to go back, deliberate, think about this, use your common sense. This is not a premeditated killing. He did not lie and wait for her to show up, to pick up the child and shoot her. It all came about as a result of the emotional upheaval, and obviously things weren't going along to begin with very well, but boy, when it came to this day, the guy on the phone and her laughing at him, etc., was just too much for him. And yes, he's going to pay for it the rest of his life. But we do ask that you return for voluntary manslaughter, which, along with a felony firearm charge, which is appropriate for the circumstances here.
Thank you, Mr. Perko. Mr. Becker, any rebuttal?
I do, Your Honor, briefly. Yes. You can see the same evidence and disagree. We go back to, he was in such an emotional state that he reacted. Such an emotional state. Once again, look at Exhibit 15, him walking out the door. Is that somebody in an emotional state? Is that him running out of an emotional state? People are mad. They go charging out the door because they slam the door. Once again, you saw it. I just played it for you. He's walking out the door. He's waltzing out the door kind of nonchalantly. That's a nonchalance. Is that somebody in an emotional state that's about to just go off? There's no emotional state there. There's nothing. Jose saying, didn't hear you yelling, didn't hear you screaming. The justification he's offering is, well, she wouldn't hang up the phone. She wouldn't hang up the phone, and he told her to. Are we 1824 here? I mean, the man says you can hang up the phone, the woman doesn't do it, boom, that sets him off. Okay, you didn't follow his instructions, so here you go. Well, once again, we go to, is that reasonable? That's not a reasonable response. That's not a reasonable response by anybody, male or female, but that's not a justification because somebody doesn't hang up the phone that you want to go kill them. That's not a reasonable response. I'm not saying you're supposed to be happy about it, but what does a reasonable person do? He goes back with his two buddies, grabs another beer and says, oh man, what the heck, that V, that's what guys do. That's what how many times is there jealousy out there? Reasonable person don't grab an AR-15 and walk out there. And they try and say, well, this isn't lying in wait. That's a whole different thing. There does not have to be lying in wait. The instruction, as he said, once again, the same instruction. There must have been real and substantial reflection for long enough to give a reasonable person the chance to think twice about the intent to kill. The law does not say how much time he needed. That's up to you. So is there enough time here to think about it? He's saying it's building, but he's got plenty of time. This has been over a half an hour. That's not enough time to think about, boy, this is a dumb idea. I shouldn't be doing this. And it's not reasonable for me to get that mad anyways. It's just not reasonable. It doesn't make sense. I submit to you one other thing in terms of it. If this is really an emotional thing. He is so distraught. He is so angry. He's motivated by love. He's so in love with this woman that he's jealous and he just wants to shoot her because he's cheating on him. How was his reaction in the interview with the police? Did he shed a tear? Did he show any remorse? You would think that. My God, oh my God, what have been done? I know it's a few, it's well after it, but oh my gosh, this is the woman I loved. Oh, I'm distraught. Did you see any level distraught? Did you see any level, I mean, this again, it was like you order a Big Mac. How many times you shoot her? Well, 4 times. So you're supposed to believe that this man who's so emotional that he can't control himself because he's in love with this woman, kind of wipes it off a few days later talking about it. Yeah, it's bad. That was his response. There's no emotion there. Which fits with him just simply walking out. She's not following his orders and blowing her away and executing her. This isn't voluntary manslaughter. It's not even close. There's nothing reasonable. There's nothing emotional. This is first-degree murder. It's an execution. There's intent. There's deliberation. He killed her for no good reason. She doesn't have a reason, and she should have been executed for sitting in her car picking up her daughter. And that's exactly what happened. It's first-degree murder. Please find him guilty of that. Thank you.
Thank you, Mr. Becker. Ladies and gentlemen, that completes closing arguments. I want to remind you that, of course, closing arguments, like the opening statements, are not evidence. It's simply the way the lawyers would like you to take a look at the case. But we're going to move directly into the instructions. I'm going to ask Mr. McKee to hand out the 2 documents to you. One will be the final instructions, the other is what's called a verdict form, and I'll go over all of it with you. Folks, I'm going to start with the instructions. The verdict form will be the last thing we look at. I'm going to read these out loud. It's obviously entirely up to you. You can either read with me, you can just listen to me, you can do whatever you'd like. But I'll do the best I can with my reading. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you have based on a witness's disability, race, national origin or ethnicity, gender, gender identity or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of this case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from witnesses, Dr. David Stark and Donna Voss, who have given you their opinion as experts in the fields of forensic pathology and translation. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts he gave for his opinion and whether those facts are true. You should also think about the expert's qualifications and whether his opinion makes sense when you think about the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. This court seeks a fair trial for everyone, regardless of the language they speak or how well it is spoken. An interpreter assisted the court during these proceedings. Please keep in mind that a person might speak some English without speaking it fluently. That person has the right to the services of an interpreter too. Therefore, you may not give greater or lesser weight to a person's interpreted testimony based on your conclusions, if any, regarding the extent to which that person speaks English. The interpreter was not associated with any party, and his only function was to provide unbiased assistance in helping the defendant or a witness to communicate effectively in court during the trial and to understand the proceedings. The interpreter was not asked questions and did not give answers, only interpreted them. He may have spoken in the first person using words such as I, me, or mine, but that was only to ensure that the court record accurately reflected what was said by the defendant or a witness. Bias against or for persons who are not proficient in English is not allowed. Do not allow the fact that the court used an interpreter to help the defendant or a witness to influence how you decide the facts or the case in any way. Some of you may know the non-English language being spoken. If you have a question about the accuracy of the translation of a witness's testimony, you may bring this matter to my attention. You should not ask your question or make any comment about the translation in the presence of other jurors, or otherwise share your question or concern with any of them. I will take steps to see whether your question can be answered and any discrepancy resolved. If, however, after such efforts, a discrepancy remains in your mind, you must rely on the interpreter's translation. The defendant is charged with 2 counts, that is, with the crimes of first-degree premeditated murder and possession of a firearm at the time of the commission of a felony, otherwise known as felony firearm. These are separate crimes, and the prosecutor is charging that the defendant committed both of them. You must consider each crime separately in light of all of the evidence in the case. You may find the defendant guilty of all or any of these crimes, guilty of a less serious crime, second-degree murder or voluntary manslaughter, which I'll address in a moment, or not guilty. The defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Leah Marie Gomez. That is, that Leah Marie Gomez died as a result of multiple gunshot wounds. Second, that the defendant intended to kill Leah Marie Gomez. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been a real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. Fifth, that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Leah Marie Gomez, that is, that Leah Marie Gomez died as a result of multiple gunshot wounds. Second, that the defendant had one of these 3 states of mind. He intended to kill, or he intended to do great bodily harm to Leah Marie Gomez, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. The crime of murder may be reduced to voluntary manslaughter if the defendant acted out of passion or anger brought about by adequate cause and before the defendant had a reasonable time to calm down. For manslaughter, the following 2 things must be present. First, when the defendant acted, his thinking must be disturbed by emotional excitement to the point that a reasonable person might have acted on impulse without thinking twice, from passion instead of judgment. This emotional excitement must have been the result of something that would cause a reasonable person to act rashly or on impulse. The law does not say what things are enough to do this. That is for you to decide. Second, the killing itself must result from this emotional excitement. The defendant must have acted before a reasonable time had passed to calm down and return to reason. The law does not say how much time is needed. That is for you to decide. The test is whether a reasonable time passed under the circumstances of this case. The defendant is also charged with the separate crime of possessing a firearm at the time he committed the crime of first-degree premeditated murder, second-degree murder, or voluntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed the crime of first-degree premeditated murder, second-degree murder, or voluntary manslaughter, which have been defined for you. It is not necessary, however, that the defendant be convicted of any of these crimes. Second, that at the time the defendant committed that crime, he knowingly carried or possessed a firearm. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about May 31st, 2023, within Kent County. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I have already given you instructions regarding lesser offenses. As to any count which includes a lesser offense, you must first consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offenses. If you believe that the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you may consider the lesser offenses. It is up to you to decide how long to consider the principal offense before discussing the lesser offenses. You may go back to consider the principal offense again after discussing the lesser offenses if you want to. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Now, folks, I'm going to ask if you would grab the second document, which is a much smaller document. This is only 2 pages. This is what we call the verdict form. And I think it's probably fairly self-explanatory, but let's go over it together anyway. So the verdict form reads, "We, the jury, in the above entitled cause, all 12 jurors being in agreement, find upon our oaths that the defendant, Luis Fabian Bernal-Sosa, is the first option, first-degree premeditated murder, that is the principal charge in the case with respect to homicide. The first option is not guilty. The second option is guilty of first-degree premeditated murder as charged. Then, the lesser included offense of second-degree murder. Again, the first option is not guilty, and the second option is guilty of second-degree murder. Then, the lesser included offense of voluntary manslaughter. The first option is not guilty. The second option is guilty of voluntary manslaughter. To just remind you of the instruction that I just read a few minutes ago, if you find that the defendant is guilty premeditated murder, you need not consider the other two. If you, on the other hand, find the defendant guilty of second-degree murder, then you also need not consider the others. And then, of course, the final option is voluntary manslaughter. The second count that is before you is on page 2, and that is possession of a firearm at the time of the commission of a felony of any of those crimes that we've already discussed: first-degree premeditated murder, second-degree murder, or voluntary manslaughter. So if you convict on any of the homicide charges, then that would then relate also to this offense. Now, a couple of things that you should know. Only the foreperson should be the one who is actually putting the check marks or the X marks on the relevant options, and only the foreperson should sign the verdict form. So all of you need not do that. Only the foreperson who you elected should do that. You, of course, may find the defendant not guilty, or you may find the defendant guilty with whatever you believe has been sufficiently proved. Also, with respect to your discussions, you should probably first consider the first-degree premeditated murder. But other than that, in your discussions, you can skip around as much as you choose to skip around as far as having whatever your discussions are. Ladies and gentlemen of the jury, during the course of this trial, I've given you some other written instructions, I think really in the beginning, as well as some oral instructions. If you feel you need any of my oral instructions in written form, please just have your foreperson write a note for that specific instruction, and we'll try to give it to you. I don't think I gave a lot of oral instructions, but if I did, then you can certainly ask me to put that in writing. At this time, folks, I'm going to ask each of you whether any of you have any questions in order to clarify the instructions that I have gone over, including the verdict form. If any of you have questions, please raise your hand. What I would always say is, if you got a question, one of your fellow jurors might also have a question, and so now would be the time. If there are any questions, please let me know. I'm not seeing any hands being raised. And now, folks, we've gotten to the time where we're going to go from 14 to 12 jurors. Before we do that, let me explain a couple of things to you. First, the way that we will winnow this down is that Ms. Vasquez is going to randomly choose 2 of the capsules that we have for each of you. It is entirely a random selection. Secondly, if you happen to be one of the 2 alternates that are chosen, that means, of course, that you'll have to leave us. Please be sure that you pick up any possessions that you have in the jury room, and then be sure that you check in downstairs. But here are some other instructions if you happen to be one of the alternates. It is not uncommon for us to have to call one or both alternates back. And that happens if there are issues that arise. For example, I've had jurors during deliberations who've gotten ill, and that means we have to call at least one juror back. Because of that, I have to instruct you that even if you are one of the alternates, please continue to not discuss the case with anyone. And also, please continue to try not to see any information, media or otherwise, about the case. In other words, you should continue to act as if you're still subject to the instructions that I gave at the very beginning. You may be wondering, I'm not even going to be here? What? And I don't know what happened? We will let you know what happened. If in fact we don't have to call you back, the jury clerk's office will contact each of you to let you know what happened, what the ultimate verdict was, because I'm sure that you'll be curious about that. Also, in view of the fact that we may have to call one or both of you back, please be sure that the jury clerk downstairs has contact information for you. The alternates may be going home, they may be going back to their job, whatever it may be. Probably a cell phone number would be best, but whatever would be the easiest way for us to contact you if we do in fact need to call you back. Yes, sir?
Is an alternate allowed to be an observer in the courtroom?
Well, I have to tell you that in the courtroom, there's not going to be much after you folks begin to deliberate. But certainly, there's nothing that I think that would prevent you after a verdict has been reached to be in the courtroom. But otherwise, once I excuse the 12 of you, you're going to be back deliberating. There's really not going to be much going on in the courtroom, but I hope that answered your question.
That does.
But once a verdict has been reached, I don't think there's an issue about you coming back. But you probably won't be advised, if you're one of the alternates, about what happened until actually after the verdict has been read out loud, just so that you're aware of that. Folks, I'm now going to swear each of my 3 staff members in as bailiffs. I do that because it allows you to be able to have contact with all 3 of them. And I'm going to ask if my staff would please rise and raise their right hands as I raise my right hand. Do each of you solemnly swear or affirm that you will, to the best of your ability, keep the persons sworn as jurors in this trial from separating from each other, that you will not permit any communication to be made to them or to any of them, orally or otherwise, that you will not communicate with them or with any of them orally or otherwise except upon the order of this court, or to ask them if they have agreed upon a verdict until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon. If you will, please say, I will.
I will.
Thank you very much, and you folks can be seated. One more thing before we draw off the 2 alternates. Once I send the 12 of you for deliberations, you will control your own time and your own breaks. Meaning, I no longer decide when you'll be taking a break. That is something that you folks will have to decide. The only thing we ask is that if you are going to, for example, go out to lunch or you're going to do whatever, you just let one of my staff members know so we can keep track of you. That's the only thing that really we would ask. And then finally, folks, when I excuse you for deliberations again after we draw off the 2 alternates, I'm going to ask that you not immediately begin your deliberations. It will only be a moment or 2. I have to take care of something in the courtroom, and then one of my staff will come back and say, okay, now you can begin. Again, I just remind you folks that the first thing, once the 12 of you go back, is probably to elect a 4th person. And now, Ms. Vasquez, I'm going to ask if you would please choose the 2 alternates again, with my sympathies for those of you that sat through a trial and may not be able to participate, but again, we may call you back.
The first juror is in seat number 2, Carlos Martinez Vargas. And the second juror is in seat number 9,
We have Mr. Martinez Vargas and that you have both given us. And again, pick up your stuff, don't leave anything behind, and please check in with the jury clerk, and please be sure we have contact information if we need to get back to both of you. And thank you again very much for your service. So you folks are free to go. And for the remaining 12 of you, I'm now going to send you back to the jury room. Let's break.
take them and put them under the case. Okay? Yep.
All rise, please. Circuit Court is back in session.
Please be seated.
We're ready. I do. Did he ever enter? Was I not listening when I entered?
Why? I think we got everything entered that he wanted.
Okay.
Traffic. All rise, please.
Kathy's going. She's got to let these guys know.
And we can all be seated.
Yes, she's ready.
Thank you, Kelly. Ladies and gentlemen, welcome back. Ladies and gentlemen of the jury, I've been informed that you have reached a verdict. If that is true, would the foreperson please rise? Mr. Foreperson, is it the case that you have reached a verdict?
We have, Your Honor.
Have you in fact filled out and signed the verdict form?
We have.
I'm going to ask Ms. Vasquez to grab it from you, please, and I'll read it out loud. Would the defendant please rise? The verdict reads as follows. We, the jury, in the above entitled cause, all 12 jurors being in agreement, find upon our oaths that the defendant, Luis Fabian Bernal-Sosa, is guilty of first-degree premeditated murder as charged. On count 2, possession of a firearm at the time of the commission of a felony. The verdict there is guilty of possession of a firearm at the time of the commission of a felony as charged. Ladies and gentlemen, I'm going to ask all of you at the same time, if each of you that has agreed with this verdict, please raise your hand. I would appreciate it. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. It does appear to be a unanimous verdict. And would you please show this to counsel? Ladies and gentlemen of the jury, I want to thank each of you for your jury service. I know your jury service has taken you out of your normal lives. I also know that this is a difficult case based upon the circumstances of the case. What I do as a judge is, of course, do what I do with these folks, but I also periodically take a look over the jury box, and it looked to me like every one of you was paying close attention, and I know that we all appreciate that as well. At this time, folks, your service is completed and you're free to go. I'm always willing to come back to answer questions, not about the verdict, but about process, et cetera, if any of you have any questions. So you can stick around and I'll come back in a few moments, or you are free to go. Again, we thank you very much for your jury service, and we will rise for you one more time. For those of you that are going to leave, please remember to pick up your stuff. Thank you very much, folks.
Thank you.
We can all be seated. First, let me give the sentencing date in this matter. The sentencing will be scheduled for March 27th, 2024 at 1:30 p.m. And I believe that by statute, the defendant is remanded.
So the 27th getting around?
Yeah, that's March 27th at 1:30. So again, I'm remanding the defendant, which the law requires, which I would have done anyway in a case like this. Is there anything else that either counsel would like to raise while we're here today?
Oh, yeah.
I want to thank both lawyers for the excellent work that you've done. Thank you, sir, very much, and thank you for our interpreter who's done such an outstanding job. We are done here, folks. Thank you very much. You're free to go.
Don't drop the stuff, little bitch. Hey, I'm not doing nothing.
That's her brother. And that it doesn't matter, that's her brother. How would you feel if her sister was murdered? If she's upset, he's not jumping over like we should.